G'day everyone, and welcome to video 4.1.2 for the legal studies guy. We'll jump into it in a moment, but as always, starting with a quote today from Amelia Earhart. Uh, yeah, an adventurer, a bit of a cultural icon. She was one of the early advocates for women and women's rights, but famously the first person or first female to fly non-stop across the Atlantic. Um, and the quote from her is, "The most effective way to do it is to do it." AKA, sometimes you just got to get things done rather than sitting around planning and trying to run through different ways and find that motivation. It's just like, hey, sometimes you just got to do things. Um, and things will figure themselves out. So, just that, I guess, message around your year 12 studies as well, that yeah, it is nice to think about the most effective ways to study and to plan that and to have a bit of an idea of, I guess, your pathway forward with what's going to work and what won't. But sometimes the best thing you need to do is to just do it. So whether it's watching this video like you're doing right now, doing a couple of practice questions, writing down some notes, the best way forward is always just to simply get started. As I said, 4.1.2 today. So we're looking at the lawmaking powers of the state and Commonwealth parliaments, including these three terms here: exclusive, concurrent, and residual power. So we'll talk about what those mean. We're going to get to the point where we can hopefully explain those things. So our essential question is going to be, how is lawmaking split between the Commonwealth and state parliaments? So from our video 411, we went through the structure and the roles of the different houses in the Commonwealth Parliament and the state parliaments. And hopefully, prior to starting legal studies this year and prior to watching that video, you were already aware that we have a parliament in Victoria that makes certain laws. And then we also have a parliament in Canberra that makes certain laws as well. So the Parliament in Canberra makes laws for the entirety of the country, whereas the Parliament in Victoria makes laws just for Victoria. And I'm not sure if you ever have, but maybe some of you have had the thought at some time for, well, how do we figure out which Parliament does what? How do we figure out who does what, and how do we make sure that they don't end up doing the same thing? How do we make sure that they don't end up making two laws that are contradictory to each other? And this is where we have in Australia what's called the division of powers. So the division of lawmaking powers, and we divide lawmaking powers up into different types. So generally speaking, each area of lawmaking power, so areas would be things like education, health, military defense, marriage. So sort of like overarching groups of laws that you can think about, criminal laws, etc. Each one of these areas is then going to be allocated to either the states or the Commonwealth Parliament, or in some instances, as we'll talk about in a moment, they're allocated to both of them. So both of them can make laws on them. Now, this all comes down to the fact that prior to becoming a country in 1901, and that's a shocking attempt at drawing Australia, do a bit of a better one here. Don't forget Tassie. Prior to becoming a country in 1901, obviously Australia was split up into uh, 6 different colonies. And each of these 6 different colonies ran their own show effectively. They were able to make their own laws. They ran their own colonies as effectively like they were their own countries. Obviously, they were all answerable to Britain still. But each colony was different. Each colony had different laws. Um, one of the famous ones, and I'm sure there's some truth to this, is that, for example, a lot of the states had different sized railway tracks just to make sure that any trains or any goods that you were moving around, because that was the main way of moving goods around back in the late 1800s, any cargo couldn't just continue on the same train. You had to stop at the border and unload it and then put it onto another train so that things like tax and tariffs could be charged. So each colony acted like its own individual country. When we're then deciding to join each of these 6 colonies into one unified country called Australia, each of the colonies was obviously a little bit concerned about losing the power that they currently had. And as we've talked about with the role of, say, the Senate as a House of Parliament, colonies like Western Australia were really, really worried that they were going to lose their autonomy, lose their ability to make laws for their own needs, and Tassie as well, for example, to New South Wales and Victoria, which were obviously significantly larger in terms of their population, not geographical area, but this is where most people lived, New South Wales and Victoria. And as a result, we know they were going to have more representation in the House of Representatives. Ultimately, the first parliament was in Melbourne before eventually it moved to Canberra, which is up in here. So particularly WA, but Tassie as well, Queensland, South Australia, they were worried that they were going to lose their ability to make laws around local issues and things that affected them to a parliament that was going to be a really, really, really long way away. So what we had to decide was what sort of things do we actually want this national parliament to do? What sort of responsibilities do we want the federal parliament to have? What sort of things do we want it to be able to make laws for everyone over? But what things do we want to just leave with each individual states so they can make their own laws for their own local context and retain some of their own autonomy? So what we came up with is what we call a division of powers. So we call it the splitting up of lawmaking responsibility between the Commonwealth and the states. So you can do this and you can do this. Okay. And what we did was really smart. We just listed, it's got some grumpy dogs in the house, sorry. We just wrote a big list and said, hey, here's a huge list. And this is section 51 of the Commonwealth Constitution, which we'll get to a little bit later in this video. But we just wrote a really big list of all the things that we said that federal parliament could do. Get back into our video there. So what do we call these different types of lawmaking powers? Well, I'm going to start with the ones that were left to the states first. So the first set of powers that we need to learn about, because remember, these words, exclusive, concurrent, and residual, were explicitly listed in the study design, so it means you can be asked a question directly about them. You could be asked to explain what residual powers are in an exam. The first one we're going to talk about is what are residual powers? And residual powers are powers, so areas of lawmaking power, that are not the Constitution, which means the Commonwealth can't make laws on them, which therefore means they are left to the states. I don't know what's going on with not being able to draw in that area. There we go. So residual powers are those that the states retained. Now, some of these were deliberately retained by the states. So things that we actually actively thought about. Hey, we're not going to give that to the Commonwealth. States can continue doing that. But some of them have developed as law areas over time. So some of them are things that we didn't think about in 1900 because it didn't exist, advances in technology, science, etc. But because they're not in the Constitution, the Commonwealth can't make laws on them, so they stay with the state. So a good example there is, it sort of comes under health as well, but IVF treatment, so in vitro fertilization, that's something that each state gets to make their own rules on because it's not something that's listed in the Constitution. If it's not in the Constitution, can't stress this enough, if it's not in the Constitution, the Commonwealth cannot make laws on those areas. And it's protected by Section 107 of the Australian Constitution, which clearly says every power of the state shall continue. So every power of the colony, every law that they had, shall continue unless exclusively given to the Commonwealth or withdrawn from the state. AKA, everything that you're currently doing as a colony, you get to continue doing unless it is something that we have very clearly said is now for the Commonwealth only. So that's a really important point because we couldn't have had a system where on December 31, 1900, all of these laws were in place in colonies, and then on January 1, 1901, all the laws just ended. And then all of a sudden it was up to the Commonwealth to try and quickly make laws to fill the gaps. We just said, hey, January 1, 1901, everything that's currently going on in the colonies just keeps happening. So every power of the states continues. So this is what we call residual powers, and these are the things that the states have responsibility over. This is in contrast to what we call specific powers, and you don't need to know that term because it's not listed in the study design. But specific powers are those that are in the Constitution. So this is the big list that I showed you a minute ago. This is the list of specific powers. So all of Section 51, and then some of Section 52 as well. If they are in the Constitution, they are the responsibility of the Commonwealth, but not necessarily the Commonwealth alone. So we have two types of powers that are in the Constitution. We have concurrent powers and we have exclusive powers. And this is where it can get a little bit challenging because it's not as clear cut as if it's in the Constitution, it's the Commonwealths and not the states. And if it's not in the Constitution, it's the states but not the Commonwealths. Most powers, most areas of lawmaking that are listed in the Constitution are for both the Commonwealth and states to legislate on. So both the Commonwealth and states can make law on marriage, for example. Both the Commonwealth and states can make law on postal services, for instance. Now, they both don't, but theoretically they can because these are examples of concurrent power. Everything in the Constitution is considered to be concurrent unless it is made exclusive. And things that are exclusive, these are the things that the states cannot legislate on. And these are things that some are made exclusive by their nature. So they're just naturally things that states can't make laws on. So we believe, for example, that international treaties, so international relations, what we call external affairs, in the Constitution, we believe that that's something that's exclusive by its nature, that states can't really be entering or making deals with other countries, although occasionally they do make some economic deals with them, I guess. But effectively, we view that as being an exclusive area because external affairs, international relations is the job of a country. It's the job of Canberra. But there's also other sections of the Constitution that restrict the states, meaning a power becomes exclusive. So, for example, defence is a good one here. Military is obviously a power that was given to the federal parliament because we wanted a national. I mean, one of the main reasons we joined together as a country was for defence, the idea that we could better defend our land if we were one country with one army and one military. So that was a power that was put in the Constitution, a specific power. And then we also put a clause in the Constitution that clearly says states are not allowed to raise their own military. Because obviously we wouldn't want this setup where we had a national army, but also every state had their own army, and then what happened? Like, it just wouldn't make sense. So that's an example of an exclusive power that's made exclusive due to another section of the Constitution. Hey, states can't raise a military, which means military is exclusively the power of the Commonwealth. Another example is money. Very clearly says in the Constitution that states are not allowed to make their own coinage. So states can't make their own currency, which again makes sense because we just want one national currency. We don't want states being able to step in and be like, oh, we're going to all of a sudden have Victorian dollary dues. It would, just be unworkable. So as a result, we say, hey, states can't raise their own currency. Therefore, currency coinage is an exclusive power of the Commonwealth. So these are our three types of lawmaking powers: residual, states, exclusive Commonwealth, and concurrent shared. We can even, one of the easiest ways to understand them sometimes is through a classic bit of junior maths, a classic Venn diagram, where we can put states over here, Commonwealth over here, and then obviously that bit in the middle, I'm writing on top of text, sorry, that they share is where your concurrent powers would go, and obviously the Commonwealth ones here are what we call exclusive, and the state ones here are residual. Now, I think one of the easiest ways to remember, because again, each of these words can be put into a question because they're listed in the study design. I think the easiest way to remember these is because what each of the types of lawmaking power is inherent in its name. So, for example, consider the term residual. Residual, it comes from the same word stem as residue. And if you know what a residue is something that is left over. So probably not something that you guys would experience anymore. I assume most people have dishwashers. But imagine if you've ever got a set of dirty dishwater in a sink. Even sometimes you have this in a dishwasher after you open it. And you let the plug out and the water runs out. And then you'll be left with like that scummy, sort of dirty, like soap around the edge of the sink. Or sometimes you'll see it on the walls of the dishwasher. That's what we call a residue. A residue is something that is left over. And this is exactly what we mean by residual powers. Residual powers are the powers that were left over. They were the ones that weren't put in the Constitution. They're residue, which means they're left to the states. So it's inherent in the name. Obviously, concurrent. Hopefully, you've seen the word concurrent before. Concurrent means two things happening at once. If things are happening concurrently, they're happening at the same time. So the word concurrent means two things at once, therefore meaning states and Commonwealth at the same time. And then exclusive, maybe you don't know if this is the terminology for relationships anymore, but it used to be back in the day. If you and a partner of yours became exclusive, it meant that you weren't dating anyone else, or you weren't going to try and be with anyone else. So exclusive is just you and you alone. No one else shared, not sharing anything, and that's where we mean exclusive powers are those that sit just with the Commonwealth. Now, flowchart. And I've said watch the video here, and that's just for my kids. We can figure out what type of lawmaking power a certain area is by working through a simple flowchart. So if we looked at the example of education, so you're all in school, so laws about schools, our education system. If we wanted to work out what type of lawmaking power education was as an area, we would first ask the question of, is it in the Constitution? And obviously, that's a simple yes or no answer. Is it in the Constitution? And in the case of education, education's not in the Constitution, which means we straight away know education is a residual power, which means it's something that is left to the states. And you'll see this in the fact that every state has its own education system. Every state has its own. Technically, we do have a national curriculum now, but every state kind of has its own. You guys are currently working on your Victorian Certificate of Education, not your Australian Certificate of Education, because Victoria has its own education system because education is a residual power. Another good example there is road laws. You will get your Victorian license. Licensing is done by Vic Roads. Because every state, because road laws aren't listed in the Constitution, so every state deals with its own. Road laws has its own licensing system. In fact, if you were in, I think, South Australia, you can get your license at 17, for example, as opposed to 18 in Victoria. Red peas, green peas are a Victorian thing. I think your first year of your peas in New South Wales, you can't drive above 90 kilometres an hour, for example. And that's because if I had road laws up the top here, say roads, licensing, etc., I'd go, is it in the Constitution? No, which means it is a residual area for the states. Now, we could have another example. We could say, what about marriage? What about laws around marriages, who you can and can't marry, what constitutes a legal marriage, what things have to happen for a marriage to be considered legal. For example, in our Marriage Act, which is a law made by Parliament, there is a specific number of things that someone running a marriage, a celebrant, has to say for a marriage to be legal. We could ask, hey, is marriage in the Constitution? And in this case, marriage is in the Constitution. So then we would ask the second question of, Is it exclusive? And how would we know if something is exclusive? Well, like I said, it's because there's another section of the Constitution that makes it exclusive, so limits the states or says the states can't legislate in that area. Or it's exclusive by its nature, the idea that, hey, that's not something states really could make laws on anyway. Now, marriage is a great example of a power that is not exclusive. There's nothing else in the Constitution that restricts the states from making marriage laws. And there's nothing inherently around marriage that means it should be something that the Commonwealth just does. So as a result, we would say, is it exclusive? No, which means marriage is a concurrent power. So marriage is an example of a concurrent power. Another example of a concurrent power, and you might be writing your Venn diagram at the moment and filling in some examples here. Another example of a concurrent power is tax. Is tax in the Constitution? Yes. Is it exclusive? No, it's not. So states can have their own taxes, and states do have their own taxes, like stamp duty, land tax, payroll tax, estate taxes. Because state governments seem to be able to raise some money as well. And there are certain federal taxes too. Finally, we have something like, I've already used the example of defence and currency, but we'll talk defence. Military defence. Is it in the Constitution? Yes, it is. Is it exclusive? Yes, it is. So we know that this is an exclusive power. And as I said, exclusive powers are those that are the Commonwealth only. How do we know defence is exclusive? Well, it's because there's another section of the Constitution that says the states can't raise a military. So if the states can't do it, if the states are restricted from doing it, it means the Commonwealth can do it only by themselves. Therefore, it's an exclusive power. This is the same with currency and coinage. So, Section 51 of the Australian Constitution, I've referenced this a few times. This is the section of the Constitution that lists all of the things the Commonwealth's able to do. So it lists all the specific powers. And as we know, those specific powers are most likely going to be concurrent, but could also be exclusive depending on a few different factors. The text of the Constitution is really clear. It says, the Parliament shall, and by that we mean the Commonwealth Parliament, because the Constitution is about setting up our federal Commonwealth Parliament. So when it says the Parliament shall, we mean the Commonwealth Parliament. The Commonwealth Parliament shall, subject to this Constitution, have the power to make laws for the peace, order, and good government of the Commonwealth with respect to, aka the Commonwealth Parliament, the federal Parliament in Canberra, can make laws in these areas. And here is your list. Hopefully you have a rudimentary understanding of Roman numerals, but if you don't, it won't matter too much. You probably can hopefully just remember the numbers. But for example, there are 39 things listed in Section 51 that are specific powers of the Commonwealth. And here's marriage, for example, 21. So the Commonwealth gets to make laws on marriage, even though the states still can. Corporations, so that's a lot of like business law around the trading of financial corporations, so banks and stuff like that. Immigration and emigration is something that we perceived to be an exclusive power by its nature. The Commonwealth is ultimately going to be responsible for who comes into the country. And then if we have a look down here, naturalisation and aliens. So becoming a citizen. Naturalisation, aliens means people from other countries. Naturalisation means becoming a citizen. Obviously, that's a federal responsibility to be a citizen of our country. It's not something states really have any ability to make laws in. You don't become a citizen of a state. You don't hold a passport for a state. So therefore, that is an exclusive power by its nature. There's also interesting ones, like a lot of us used to believe that, say, quarantine. I certainly had a misguided perception that quarantine was an exclusive power, like, things coming into the country, things being put into quarantine, which means they have to go to a certain spot for weeks at a time before they can be released out in the community, often with plants and animals and things. I naturally just assumed that this was exclusive because clearly states wouldn't be doing that. And then COVID-19 happened and the federal government didn't want to set up a quarantine system. So every state set up their own quarantine system. through hotel quarantine, and quickly realised that quarantine is very much a concurrent power because states can still make laws and rules in that area, for example. So you can have a read through this list. You'll see taxation very much is a um, concurrent power. It's listed the Commonwealth can raise taxes, but so can each individual state. Things like uh, invalid and old age pensions, provision of maternity allowances, hospital benefits, medical and dental services, all things that the Commonwealth is able to do. And these were things that were actually added at a later referendum. The control of railways, Commonwealth, so on and so forth. So you can have a read through these and see all of the different examples of things that the Commonwealth gets to do. And then contrast that with some of the things that you maybe don't see in this list, which you'll hopefully notice are things like health and education, and generally speaking, quite broadly, criminal law. So obviously, the Commonwealth can make like there is federal courts, and the Commonwealth can make certain acts criminal in the sense of if you break the law regarding one of these areas, it can be constituted as a Commonwealth criminal offence. But broadly, criminal law, the idea of social expectations and behaviours, that's something that each individual state runs, which is why we have a Victorian criminal justice system and a Victorian civil justice system, for example, as well. Our key skill here is the task word explain, and we just need to explain the lawmaking powers using examples. So we need to be able to know some of those examples that I've listed throughout this video. And just an explanation, as we know, is always the idea of showing understanding. So it's more than a definition, and generally examples are a great way to show understanding. So showing that you know this in a little more depth, and that would generally be by running through that flowchart in a way. Hey, how do you explain what a residual power is? So you start by saying it's not in the Constitution. By the fact it's not in the Constitution means it's left to the states, which means the Commonwealth can't legislate in this area, so on and so forth. This was the 10-mark question on last year's exam, so the 2023 exam. Discuss the extent to which the High Court has had an impact on the division of lawmaking powers. Now, this is something that we'll come back to in some future videos, the idea of the role of the High Court. But more importantly, I want to focus on this part. In your response, explain the ways in which these powers are distributed between the state and Commonwealth parliaments. So division of lawmaking powers, explain the way the division of lawmaking powers is distributed between the state and Commonwealth Parliament, which is exactly what this key skill is. So last year's 10-mark question, a portion of that answer had to be basically completing this skill. And luckily, VCAR gave us a beautiful sample answer that included that description. So here is a great description of those lawmaking powers. The Commonwealth Parliament can legislate in exclusive and concurrent areas. Exclusive powers are outlined in the Constitution as being exercised solely, so keyword there, by the Commonwealth Parliament, such as currency. So one of the ones we talked about, currency and coinage. Concurrent powers are in the Constitution but belong to both state and Commonwealth, such as marriage. So again, using the example. Finally, residual powers are not outlined in the Constitution and thus exercised solely by the states, such as environmental law. So something that's not listed in the Constitution. And environmental law is an interesting one that we'll talk about in a future video around the role of the High Court. Because maybe you've already realised, well, what if there's a law made and it kind of goes across multiple areas? How does that work? And this is something that often comes up then in the High Court, and the High Court has to decide really who actually has responsibility over that. So we'll talk about that in a future video. But here is a great little explanation just showing you, hey, Commonwealth have concurrent and exclusive solely, concurrent shared with the states, and then states have residual. Again, the PEO website is a great one to look at, and there's actually a great little game on there that you can play if you follow this link, so I'll put it in the description below, where you get to drag some different powers around and try and put them in the exclusive, concurrent, residual boxes. So you can further, again, your understanding of what different things your state parliament versus your Commonwealth Parliament are doing. Look, hopefully, if someone says to you, "Hey, God, there's meant to be like an election coming up soon, like federally, but then didn't we have a state one not that long ago? And then why do we have two parliaments? And what's the whole idea there? Isn't that a bit confusing? Aren't they just doing the same thing?" Hopefully, you'll be able to say to them, "Hey, look, this is how lawmaking powers are split between them. This is what they do compared to what they do, and this is why we need both of them." If you can answer that essential question, you have absolutely nailed this dot point. You'll be ready to explain those lawmaking powers and hopefully nail any upcoming SACSA exams you have. As always, feel free to leave feedback below, but happy study.